Excellent. Okay. Yeah. You said the go. Okay. So we've got lots of people joining us at the moment. I've just sent out a message to Madam Njeri. I'm
Okay,
hoping she'll
so
join. Can you
okay,
hear
so
me loud and clear?
yes, we can. So we can go ahead.
Okay, so I would like to welcome everyone on this webinar, this very special webinar hosted by CIRB Nigeria, and it is in honor of sports disputes. And coincidentally, we are celebrating World Football Week this week, the very first World Football Week inaugurated by FIFA, which is why I'm wearing a jersey today. So I just thought, in the spirit of sports, football, to put this on. So want to also say a very big thank you to our special guests, Mr. Leandro Toscano from WIPO for honoring us, and also uh, Jane Njeri Onyango from Kenya. She's one of the foremost sports arbitrators and sports governance professionals in Kenya. I think what I'll do is I'll just begin with a very little, maybe say, intro to set the tone for today's webinar. So we're hosting a webinar dedicated to sports disputes. I'm sure many of you arbitrators, mediators, conciliators, where you find yourself in the ADR picture, will be either already practicing as sports ADR professionals, or perhaps you're interested in getting into the space. I can tell you it's a very exciting space to be in. It's $1 billion industry, the world of sports, and sports cuts across so many things. And I think for many of us, we tend to think first of all about what happens on the pitch, what happens on the field, what happens on the courts. But I'm really looking forward to Leandro breaking down the commercial side of sports, which encapsulates intellectual property, for instance. So commercial sports disputes are growing by the number. Globally, the value of the sports disputes industry runs into the hundreds, and it covers stakeholders cutting across from the athletes themselves, the players, the coaches, even the fans, but also those who support the industry, such as the people who construct the places where we go to enjoy sports. Let's not also forget sports, esports. I had the pleasure of attending that Leandro was a part of the other day on esports and what's happening in the dispute world in that area. So you are in the right place. There's a massive opportunity in sports wherever you're coming from today. So whether you're in Nigeria or you're logging in from another part of Africa or maybe from another part of the world, today, our mission is to tell you that there are massive opportunities in sports. It's a fast growing industry. And wherever you have a lot of commercial activity, you're going to have a lot of disputes. So this is a great time to position yourselves to tap in to this sector. So what I'm going to do now is I'm going to begin with Leandro because Leandro is here with us. So I'm just going to read out Leandro's profile. Leandro, I hope you don't mind. For those who may not know you, I will read his profile. But just to let you know, he works at the World Poverty Organization. So he is a lawyer by background, but he's also the head of business development and digital content disputes. Of course, we all know that disputes have taken on a virtual angle. We no longer have disputes only physically in person. You also have of ODR. So he heads up that area on the WIPO. As I said, he's the head of business development and digital content disputes of WIPO. He's based in Geneva, Switzerland. He obtained a law degree from the University of Buenos Aires and pursued further studies in international dispute resolution, earning an LLM from both Queen Mary University and UCL, University College London. Additionally, he also undertook a specialization in intellectual property and IT law from the Catholic University of Argentina. Leandro previously represented the WIPO Center in Singapore from 2011 until mid-2014. And then prior to joining WIPO, he worked in private practice, specializing in IT and information technology law. So he's more than qualified to speak to us today on the angle of sports dispute. So let's get into it. first of all, thank you so much for being with us. And I guess as an overview, you work for WIPO. You've done many people on this webinar probably recognize you because you are really truly become the face of mediation, arbitration, and WIPO. Can you tell us a little bit about what your organization has been doing around sports in the last couple of years? Thank you.
Hello, Beverly, and it's really a pleasure for me here today with you and with all the friends that are joining. Special thanks to CR Nigeria branch for this kind invitation. It's always a lovely opportunity to share the work that we do at WIPO in this opportunity with regards to the world of sport. And as you mentioned, commercial matters are very much present in this multi-million-dollar industry. We are seeing more and more activity. There's a lot of activity happening in the digital environment with everything that is related to streaming, for example, video games that are related to sports. So there are many angles that are perhaps not the so called traditional in commercial disputes. And again, it's a lovely opportunity to be here. So thanks for that invitation. For those that are not familiar with WIPO, WIPO is the World Intellectual Property Organization. It's the specialized agency of the United Nations that offers a forum to deal with everything related to intellectual property with a mission to bring IP everywhere so everyone can benefit from their ideas, their innovation, and they can protect such ideas and innovation and also make a living, right? Coming from this. In sports, there's a lot of technology involved. There's a lot of matters that are protected by intellectual property. If we look at trademarks, we can talk about patents. We can talk about copyright when it comes to everything related to, for example, image rights or broadcasting. So keeping all these things in mind and using our expertise in other more traditional IP intensive industries, we have been working with different stakeholders throughout the years to expand the knowledge on ADR, the culture of dispute resolution in this sector. So I can name a few very concrete activities that we have, for example, collaboration with institutions like the Olympic Committee to promote intellectual property and how to properly protect and defend your rights, including through whenever it's necessary, the use of alternative dispute resolution mechanisms like mediation and arbitration. So we're constantly looking for these possibilities to spread the word. And we have also, of course, administered a number of cases coming from different areas, different parts of the world, involving athletes, companies, federations, organizations, broadcasters, so a wide range of different stakeholders in this industry. Also including in the area of domain names, for example, WIPO is the leading provider of internet domain name dispute resolution services. And it's not strange to see a lot of domain names being, as we call it, cyber squatted whenever there's an international competition, when you have the World Cup or the Olympic Games or the Euros or any other relevant competition, that someone goes in advance and in bad faith and registers this domain name. So then the true right holders need to go and recover these domain names or cancel them. So WIPO makes available a mechanisms for that. So in a nutshell, I can say that we are very much involved in the world of sports as WIPO. There's WIPO, a task force on IP and sports, so we're constantly doing activities with the different actors of this ecosystem. And in dispute resolution, we have a good experience in terms of the different IP and commercial matters in the world of sports.
Okay, great. I'd love to just delve a little bit more into these IP matters that you've experienced seen in sport. Again, a lot of people don't necessarily think of IP when they think sports, they automatically think maybe a player has his rights breached. So maybe let's move towards the commercial side of sports a little bit more. So you've talked a little bit about IP issues in sports. Can you just paint a picture for the audience who may not be familiar? How does IP materialize in sports, and what type of IP disputes are common or have you seen in your experience in sports, so that they in the audience a bit more familiar and will be able to spot the opportunities when they come up? Thank you.
Excellent. Yes, I'll give you a few concrete examples in the different type of IP rights that we have seen. So, for example, in the area of technology, innovation, patents, we have seen matters related to patents in sports gear, right? So there you normally will have like the inventor, the manufacturer of the product involved. We have seen cases where there are licensing agreements where the inventor licenses its technology, patented technology, and protected in different countries to a manufacturer of sports goods. And maybe there's an issue regarding payments of royalties or infringement, for example, using the technology in a territory that was not agreed to be used to. In the area of trademarks, this is also quite common when there's a company that gives a license, and sometimes we're talking about exclusive licenses, so only that partner can manufacture and produce in a certain territory. So for the brand owner, it's a very big commitment, and it's a very important business opportunity. So if there's any dispute, then imagine if you need to litigate for 4 or 5 years in court to somehow get rid of that problematic partner that is breaching the contract, not respecting its obligation. So then mediation, arbitration offer these opportunities to either renegotiate an agreement. That's something that we often see in WIPO, where we see a 70% settlement rate in mediation. So it's quite high. So there's an opportunity to find a win-win solution. And even in arbitration, where the objective is to reach a decision that is final and binding, enforceable. Even in those cases, we've seen about 30% of the cases that the parties reach an agreement before the award is issued. So there's a lot of room for settlement in IP disputes. That's been the case in sports-related disputes. Then in the area of copyright, we can mention broadcasting rights, like TV rights, for example. We have seen cases where there's a competition and a federation grants rights to a broadcaster, and there's an issue. And of course, it's very important, the timing, right? Because of course, if there's an issue when the competition happens, that can have a massive impact on the deal, and of course on the commercial side. So we have seen cases where the parties agree to have like an expedited arbitration, a short version of arbitration to resolve the dispute due to the deadline, right? Because the event is happening. So that's quite common. We have also seen issues related to image rights of athletes, right? The use for advertisement, for example. Sponsorship we've seen cases, for example, related to technology use to show advertisement to digital means. When you're watching a game and you see this advertisement, well, there's technology behind that, and again, agreements and licenses. So we have seen that type of cases also coming to us. Then we also work with some competitions, for example, the America's Cup, which is a sailing competition. It's a very traditional, well-established competition that has different races around the world, and eventually there's a final. And there they have their specific tribunal for disputes that are related to commercial matters, but also to matters that are proper from the race, right? So to say like, okay, who's really arriving first or not. Then there are issues related to, is the boat design, was copying the design of another boat. So it's quite an interesting array of disputes. And there the tribunal uses our case management system. So we grant a license to them. and they use the technology that we develop, a WIPO, to file the cases and to do all the case administration. So that's another area where we can also assist. And I mentioned domain names before. Domain names is something that is quite common to see someone registering the name of a famous athlete. We have dealt with cases, for example, LionelMessi.com, right, to give you an example of big, and then World Cup, FIFA World Cup matters, or UEFA, or Olympic Games, or other competitions in other disciplines, football teams, matters related to websites that are selling tickets for games, for example, and they use the name of a club without any permission to do so. So it's quite interesting. Athletes in tennis also, and it's quite interesting because sometimes it's more the situation where there's a fan that registers a domain name and then has a fan site, and then all of a sudden gets a claim saying like, well, you're cyber squatting this. So it's like, no, this is my idol, so I want to give it back. So it's not necessarily bad faith in all situations. But it's often we see that there are opportunistic people out there waiting for these events to be announced, and even you see cases, when they're candidates to host an Olympic Games, so all the different cities are registered as domain names, just in case if any of these candidates win. So that's quite telling and quite interesting. So again, we're seeing a lot of these issues. More recently, and I think you were present when we introduced this new tribunal on esports. This is what we call the IGET, the International Games and Esports Tribunal, which is brand new and has the intention of bringing dispute resolution tools to the esports industry that is growing. And as we know, video game industry these days, it's bigger than the film and music industry combined. So it's a massive industry. It's there's a huge fan base everywhere and a lot of commercial deals. So in the esports area, we see, apart from the traditional integrity matters of cheating, for example, or doping that you will find in sports, we are seeing all these commercial matters happening, and that's why, well, we try to also play a role and to help there. So that's just to give you a broad
Thank
overview
you.
of our experience in the area.
That was fantastic. That was really broad and sweeping. So everybody's got a sense of all the common issues happening in sports. So at this juncture, I would like to bring our second speaker, Mrs. Jane Njeri Onyango, and she is actually an expert in the area of integrity, governance issues. She's actually quite the superstar. So I'm just going to read out her profile, and hopefully the spotlight can be shown on her, can shine on her so everybody can see her. So I'll just read out her profile briefly. She's an advocate of the High Court of Kenya. She's also a fellow of CIR, but also a mediator. She boasts a 37-year legal career marked by involvement in complex litigation and has consulted in various fields, inter alia, consumer protection, the Sports Act 2013, Anti-Doping Act 2016. She's been involved in various sports federations. And should I say, she's also an ex-athlete herself. She's a commercial and civil law litigator, and she's fully transferred into CR. She served as an assistant counsel in significant commissions, such as the Kriegler Commission in 2008, which conducted sports malpractice investigation. So this is the integrity issues that Leandro had raised. She served in various boards as well, public sector boards, banking boards. She's made significant contributions to boards. I said she's already, I said previously that she was an international athlete in volleyball, taekwondo, lawn tennis. She's held various high-level positions, including serving as vice chair of Tennis Kenya for over 12 years. She's also a member of the Kenya Football Premier League Disciplinary Committee and acting as honorary secretary to Parkland Sports Club, amongst other roles. She served in both the National Olympic Committee, K, and the Kenya National Sports Council. She's been a member of the FIVB League Tribunal since 1996. She served as a member of FINA, which used to be called Aquatics, and she also belongs to FIDA, IB, and LSK. She is currently serving as a member of the Sports Disputes Tribunal of Kenya, so a panel member of Sports Resolutions UK, and is current chair of the African Continental Results Management Panel of WADA. She was further elected as the vice president of CAF disciplinary board, and she participated recently on the disciplinary board in the recent AFCON 2024. She's a certified mediator and has handled numerous mediation proceedings, including court annex mediation. I mean, her profile goes without saying. It's illustrious, it's long spanning, and she's a lady that really has built a name for her, not her home country or on the continent, but globally. It's a pleasure to have you with us, Mrs. Onyango, and thank you for being able to join us. So, straight into it, because we don't have much time. I think everybody is probably eager at this point to ask, okay, work points, sports is exciting. There's so many dimensions. How do we get into it? There's probably arbitrators, mediators right now on this webinar wondering, how do I approach? How do I get in? So I think I'm going to ask you a very, it's more of a career development question, Mrs. Onyango. What's the best way to start a career in sports dispute resolution like yourself? How do you build the foundation to get into this career and create a path for yourself? So I'll let you take the floor. Thank you. And we will have questions in about 20 minutes because I really want people to hear from both of you and ask their questions. So I'll let you to present and we'll take it from there. Thank you.
Thank you. I don't know whether, first of all, my apologies for logging in late. I think I had challenges and I had to get back to you to assist me. So sorry about that and good afternoon, everybody. You've just read something that I wondered whether it was reflective of me. I didn't know it sounds that bad, but there we are. I don't enjoy the kind of modern issues that my dear friend and co-presenter Leandro has. But in Kenya, and those of you who are of my age, sports was a waste of time. My mother would beat you about it. And so I started from the point where it was something that was bad. But I was lucky to go to schools that encouraged both sports and academic performance. And then I just got people along the way who made me think I could do more than that. First, by the basic, I tell many Kenyan athletes, legal practitioners, is you must start by offering service. And then people see you, then people give you opportunities. And I've been a lucky recipient of many people's trust and opportunities granted. And therefore, I started by doing pro bono work for many of the federations. There were not many lawyers in my time, considering the number of years I've practiced law, that were involved in sports. So mine was purely accidental. Then thereafter, I think I made a purposeful now progress when I realized what it would mean. For instance, when I participated in a World Cup in volleyball, the next year I got married and started having children. And the federation came and said, look here, come and be a team manager. So I came from the bench to management, no experience, nothing. So luckily I was able to develop myself on that line. And the other federations also would then come and say, we have a dispute, can you help us? We have a problem with our constitution, can you have a look at it? And that's how I picked up, and you'll see that I have then had to go to various fields. I was in team sports most of my time, and I thought, well, team sports is not working for me. So when my children came along, I said, let me take them to individual sports. Then I got myself deeply into swimming, into lawn tennis, into many other fields. And I think the best I can tell somebody is to first offer the services and then look out for the opportunities. Leandro has just spoken about esports. shock on us. Who expected that 10 years ago? Esports was non-existent. Now, I have in our tribunals, we are having disputes between esports federations and the traditional federations. Who is the king of the sport? Is it the esport federation? Is it the traditional federation? There is room for growth. It's the world open, and as dispute resolvers, our best is to stay knowledgeable, keep learning, and then people will come to you. It's not nice when people come to you and you tell them, I don't know it. You find out, then you tell them, oh, now here is a solution. So it's a question of being purposeful about developing yourself in whichever area you choose, whether it's football, whether it's athletics, whether it's tennis. And the disputes are as wide as the sports are growing. The industry is, I think, the richest. Who is richer than the best sports person presently, apart from maybe the Elon Musks? But the rich people, when they are counted, the sports people are in that line. And I will tell my fellow dispute resolvers, it's a wonderful stage to be in. So I hope there's no formula really. Just have some interest. Offer service. At the beginning, it may not be as attractive, but it will come along as you gain experience and people see and make decisions that make sense, and people will therefore keep coming back because they can rely on you, on your decision-making capacity.
Absolutely. Thank you, madam. I really appreciate how you kind of set the tone and explained how you found yourself in the industry. Now you've already given us a clue that you have tread the path along the line of integrity. You seem to be more at home with, and this could be because you're an ex-athlete, so you know where all the pain points are. You know all the major issues that athletes have experienced. So I think I want to ask this question now. How does one choose what path to follow? So for instance, with me, I kind of like both the commercial side, which is the IP side, but I also really am passionate about human rights. I'm passionate about upholding labor laws, employment rights, and things like that. Is it realistic, though, to be able to do both as a dispute resolver in sport? Or is it better to pick a path, for instance, be a Leandro and focus on commercial areas in sports, or your passion leads you and you go down the line of, say, governance issues, you sit on disciplinary boards? Is it possible realistically to do both, in your opinion?
Well, sitting from where I am, I think I've been the jack of many trades in terms of the sports dispute resolution. I've done. I've gone through almost the entire package of it, but I do think specialization is really, really important because of there's the basic issue about fairness in sports. There's the basic issue about good governance, but then there are areas which I would today have to run to Leandro, since now I've gotten to know him. It's much easier. But when you're sitting, say, in a tribunal, like I have been sitting in the Kenya Sports Disputes Tribunal, unfortunately, the entire package comes. The Kenya Sports Disputes Tribunal has has generally a wide mandate to deal with matters sports. And recently, the High Court did say that any contract, when there is a contract, a breach of contract on employment matters, the tribunal can handle that as well. Then we have also the other jurisdiction of doping. So you see, when it comes to such a structured institution like our Sports Disputes Tribunal, then the knowledge of all those areas would be really necessary. But for purposes of proper improvement, I would advocate for specialization. I know I have done the sporting bit, the disciplinary, and then now I'm in the WADA, the anti-doping. But I tend to think that specialization is really, really important. There are nuances about the commercial aspects of the sports, which I would not say I'm an expert in. But if you brought me to doping, if you brought me to governance issues, ethical issues, then I'm really, really much more at home.
Now, I have a question which I'm going to pose to Leandro, and this is what method of ADR seems to be more popular? When you look at arbitration generally, or rather outside sports, generally we've seen that arbitration has been the preferred method for resolving commercial disputes, but we've seen a shift towards mediation. Would you say that an institution like WIPO is also becoming more open and accepting of mediation as a method for dispute resolution? Again, this is for the purpose of our audience who may be thinking the track to being an arbiter might be quite long, or perhaps I should go down mediation. So and I will ask you this as well, Mrs. Onyango. Leandro, could you just tell us, on the balance of what are you seeing is more popular, arbitration or mediation to resolve disputes? Is one more preferable? Is there a trend? It would just be nice to understand, what the trends are looking like now.
Great. Thank you, Beverly. And first of all, like to say thanks to Jane also for joining, and it's a very impressive CV and very, very diverse. So congratulations on that. And thank you for sharing all your valuable experience with the audience today. So, the answer is it depends, right? So I think it's all about the strategy when resolving a dispute. If what you're looking for is try to renegotiate the terms of a contract, for example, try to find some collaboration opportunity, then mediation offers a more suitable forum, because there you will have the neutral intermediary, the mediator will help parties to try to reach this so-called win-win solution. And as I mentioned earlier in this session, there's a high settlement rate that we observe in IP matters. So it's very suitable mechanisms. Also, the barrier of entry is much lower. So it allows, let's say, smaller actors in the ecosystem to access these alternative dispute mechanisms. In arbitration, what we observe is that normally larger disputes are referred to arbitration, more like in the areas of larger patent cases, for example, where there's a lot at stake. We have seen also many matters related to trademark licenses, but more to expedited arbitration, which is a compressed version of our standard arbitration, and it's also less expensive. When you go to arbitration, normally you have to have your lawyers need to be specialized in arbitration, because the process is very important, how it's handled when you have cross-examination, when you're in hearings, how you present your evidence, the pleadings. There's a lot of documents involved, so it's a lot heavier than in mediation. In mediation, normally you would have maybe some statements. It's a lot more flexible and formal. Also, when you accept to participate in arbitration, then you are closing the door to court proceedings normally, right? While in mediation, you can step out any stage. So what we have is, normally we recommend the escalation clauses or multi-tier dispute resolution clauses, where you have a first stage where you try mediation for a period of time. And it's quite important to indicate the period of time to avoid any non-cooperative party dragging on, right? So you say 60 days, and from day 61, any party can move to arbitration. So if you're not comfortable with how mediation is, if the positions are too far apart and you don't see a chance to reach an agreement, well, at least you try, and then you move to an already agreed mechanisms. Also, we have observed that in some instances, parties manage to clarify the scope of the dispute in the mediation process. So sometimes it looks like it's a much larger dispute or many other many items to be resolved, and perhaps it's not so much like that, and then they only refer to arbitration, the pending matters. So that's important. Sometimes we also see that parties want to push and go all the way to presenting all the evidence, all the pleadings, and maybe when you see all the cards and you have more information, maybe then there's scope for settlement or not. And normally, when the parties reach a settlement in arbitration, they would then require or ask the arbitrator or the tribunal to render a consent award. And that's basically reflecting in the award the agreement that the parties reach. So if there's any party that in the future does not comply with the agreement, you can enforce the award through the New York Convention. So that's another mechanism. So in the end, in a nutshell, I would say it depends a lot on the strategy. We are seeing at WIPO a massive increase of mediation because we are seeing a lot of, let's call it low value, high volume disputes. Right. So when you see like disputes that are smaller, especially in the context of the digital environment, there's a lot of disputes related to content sharing, audiovisual, music, images, use of photographs without consent. So these cases that perhaps the value is not so high, so you wouldn't go to the courts. It's international because it's someone infringing in another jurisdiction. So these cases where normally you can go through the platform and get some solution, but if you can't, then WIPO offers a possibility to use mediation, to invite the other party to mediation. And of course, we are always talking about consensual procedure for both mediation and arbitration. So everybody has to agree to be part, as opposed to court proceedings when you just file your case in the relevant jurisdiction. So mediation, very popular. I think there's a lot of room also for other procedures like expert determination. It's very much underused, and we have run some surveys in different areas in the last few years. When we ask about the perception of the different mechanisms, oftentimes we see that expert determination, there's a high percentage of people that says, I don't know, but the perception, right? I don't have, because that might be linked to the fact of not having awareness, not knowing how it works. So I think we can work also more on this area, and it's very much using, for example, valuation of IP rights, but there's scope for more use of this technical dispute resolution mechanism. So I hope to have covered more or less, your question.
It did. And just to quickly recap before I move on to Mrs. Onyango, what I'm hearing from both yourself and Mrs. Onyango is, don't be tempted to be broad. People like Mrs. Onyango came into the industry at a time when it was green. Now is the time to specialize. So, and also because we want to capture a broader market, like what you said, Leandro, those slightly smaller deals, maybe SMEs that have IPs but are not necessarily ready to go the whole hog with arbitration, they are more willing to go through mediation. So certainly for everyone listening, and especially if you're new to this sector, and it's easy for all of us to reach out to contact SMEs or maybe an athlete. Everybody knows someone in sports. Mediation might be the way to encourage them to resolve their disputes without prolonging it or excessive costs. Now, I want to turn to you, Mrs. Onyango, and again, given your background in integrity, issues, and of course, you have the benefit of being part of a very well-structured sporting legal system. You've got the Sports Act 13 of Kenya, which has given the possibility of having a sports disputes tribunal. That is a game changer for Kenya. So you've talked a lot about having the benefit of being part of that system that has helped giving you a structured exposure to various disputes. Now, what would you say to people who don't have the benefits of being part of the system as, say, a sports act? I'm Nigerian. We don't unfortunately have a sports act. So it can be difficult to encourage stakeholders to resolve disputes formally. There's this tendency to want to do it formally, and sometimes the federations themselves are not much help. So what would your advice be in terms of trying to grow your career in a system that doesn't really have structure, but you're passionate about it and you still want to make your mark? What would you say to that? Because I'm sure there's many people on the call who are not from Kenya or not from Europe or America and are still passionate about being dispute resolvers in. Thank you.
Thank you. I do hope I will be able to help my colleagues in this. Before we had our sports disputes, our Sports Act 2013, I will agree that the system of resolving issues was fairly fragmented. But I think when I was in the National Sports Council as well as the National Olympic Committee, what we did then was to prepare some rules under the National Olympic Committee, which then were brought to the Congress of the Olympic Committee and were adopted, which featured a structured way of managing disputes from the federations. But you will notice that most of that was aimed at governance issues, not the player contract, the player transfer, the rights of a player, nationality, and issues like that. So one of the things that we did then was to, of course, prepare rules under the National Olympic Committee, which then helped in resolving some of the governance disputes within federations, either within the federations or against federations. At one time, we had Kenya Golf Federation and Kenya Golf Union, or Kenya Hockey Federation and Kenya Hockey Union. So those kind of disputes then for the sports that were under the National Olympic Committee were much easier to deal with, because then there was some structure under the National Olympic Committee. Unfortunately, territorial wars also came in, because the federations felt it should be people within from the federations who then get fed into that space. So for purposes of resolving that, it would then be interesting for our various CIABs, our various branches of the CIAB to have execute agreements with either the national federations or the umbrella, what I would consider the umbrella national federations, like the National Olympic Committee, the National Sports Council, the National Paralympic Committee, to execute agreements with them and say, look, when you have disputes, come to us, we'll appoint for you persons who are either passionate or knowledgeable in that area, so that what we have now done in Kenya, although it's now become part of our law, but even before it became part of the law, the National Olympic Committee and the National Sports Council did insist on having clauses within the federations of various sports to include a dispute resolution clause, so that either you go to the National Olympic Committee and use that structure within the National Olympic Committee, or use the structure then under CIR if there is an agreement executed between the two entities, so that now you get the experts, and through that forum also, with the mentorship arrangements that are there with the CIRs, you get people then coming to under your wings, the wings of those who have
We've lost her. Okay, you're back. Okay. I think we've lost her briefly. Okay.
Experts ahead of them to learn and grow. So a link between the various chapters of the CIABs and the sporting federations through the umbrella federations would really help, because then it would structure this. Thank you.
Fantastic. Thank you, madam. That's a fantastic suggestion. And maybe at this juncture, I should also ask Leandro, what kind of arrangements are they making to support federations, maybe sporting bodies? Because ultimately, everything we've heard today, we need to be able to apply in practice. I want people to leave this conversation thinking, okay, I need to know what clauses to start putting in my agreements. If they're employment agreements, what kind of clauses should I be putting in? What kind of ADR clauses? Who should we have recourse to? So Mrs. who has made a great suggestion about maybe CIR should interface with federations at home. WIPO, it would be great to know. I mean, I'm not putting you on the spot, but definitely these are the practical things. We need more collaboration. That's truly what it is. More collaboration between these institutions, esteemed bodies like CIR, WIPO, to support the work of the federations, the associations, when it comes to non-commercial issues. So it would be great to have your take before we just take some questions very quickly. Thank you.
Thank you, Beverly. Before starting with the question, I wanted to put in the chat a link to a program that we offer to young professionals. That is the WIPO ADR Young. And that's a forum, it's a free membership that professionals under 40 years old are invited to join. And then they get invited to different events. We have some virtual networking sessions and essay competitions, etc., to encourage the use of or the learning of ADR for IP and commercial disputes. So they're all invited to join that. And then going back to your question, well, we are constantly in contact with different actors of the sports industry, sport ecosystem. For example, I mentioned that we have a collaboration with the Olympic Committee. We often talk to federations about the benefits of ADR. We are here, in Geneva, in Switzerland. Close to Geneva, we have Lausanne, which is the Olympic capital, where the Olympic Committee sits, and there are many sports federations. They are like a federation for motorcycle, or FIBA for basketball. So UEFA is also here. So we have contact with the different teams, the legal teams in these associations or federations to inform them of the benefits of using ADR. They are familiar with arbitration, of course, more from the CAS or TAS angle, more for that kind of disputes. But also Switzerland being, a very let's say well-known, well-reputed place for dispute resolution. It's not uncommon to see arbitration and mediation clauses in sports-related disputes. So that's what we try to do. And then with the national federations that are not based here, of course, we're always open to talk to. I invite Jane, for example, if you ever want to have us like talking about the benefits for a federation in Kenya, or Beverly, same in Nigeria. We're very happy we collaborate with different institutions. For example, in both Kenya and Nigeria, we work with copyright offices. So we have ADR programs there for mediation that in some instances also are related to sports disputes. So we're very happy to build bridges and to join forces constantly with the relevant institutions. For esports, we partner with ESIC, which is the Esports Integrity Commission. So we do the commercial and IP part, and they deal with the integrity matters in this new tribunal. Joining forces and working together, it's always very, very important, as you all said, and WIPO is always open to collaborate.
Nice. I think at this point, I want to invite members of the audience to please post their questions. We don't have time for too many. I think 3 could work. So this is your opportunity to ask that burning question that you might have, whether it's what are the tribunals you think I should apply for? And remember, Leandro talked about a very, very brand new tribunal for esports. Even I have applied, I'll say, because opportunities are to be taken. So that's one opportunity, the esports I get tribunal. I'll drop that I actually work, well, I mediate on the FIFA mediation panel. They don't have openings at the moment, but I think it's something that we should generally get into the habit of, checking out websites every now and again. So you have the mediation panel that I belong to. Madam Onyango, for people in Kenya, do you have any advice on how they can maybe shadow, intern, just to get arbitration experience? Maybe Sports Disputes Tribunal Kenya might allow people to shadow or come in, or what's the best way people can get experience at the tribunal, or do they have a panel, for instance? So I'm just asking everyone to post their questions. Hold your thought, madam. There's a question here. So this question is from Joe Kimani, and that's the Kenyan name. You're very welcome to this webinar. And he's saying, where does sports agency fall under sports law? And how can I get certified? Well, that's technically not a dispute question, but I'll let either of you do. But please keep your questions tied to dispute resolution if possible. Second question, as a basketballer on a middle tier league in Kenya and a young lawyer, should I balance law and sports or focus on one? I think, Mrs. Onyango, that's for you, because you are an athlete and lawyer, well, athlete turned lawyer, now exclusively dispute resolving. Can you take number 2, please?
If you are a good basketball player, maybe stick to that. It's more fun.
I know, right?
Yeah.
Right.
Well, Beverley, I would say this: it's a very good marriage. The spouses are very agreeable. The sport and the law. I think it's the best marriage that I ever came across. Under the Sports Disputes Tribunal Kenya, we have a pro bono lawyers list. So the gentleman asked about how to get in. We have a pro bono lawyers list. We did realize when we joined the tribunal in 2014, and I was the architect of the Kenya Sports Anti-Doping Act that was given to me to do for Kenya, and I gave the jurisdiction to the Sports Disputes Tribunal because they wanted an independent body. Then we realized those of us who are the experts are already in the tribunal, so who will represent those who come before us? And many times your decisions are spiced up or even improved by the challenges you meet with a lawyer who passionately represents the dispute of their client. The doping is extremely technical, and many times, unfortunately, do not want to belittle my country. Many of our athletes are not as exposed as I and Mr. Kimani or whoever has asked that question. You'll find that most of them have had the basic education, either primary level or secondary level, and therefore they do not understand those very technical. Even I struggled, and many times when we sit even under the UK sports resolution on doping matters, even we lawyers ask for the presence of medical experts to come and sit with us. So we said, what do? We then established a pro bono lawyer list. And so the good gentleman who is a basketballer and a lawyer, that's a good starting point. It will force you to learn. It will force you to give service. You do good for your country as you do good for your own CV as well.
Thank you so much. Next question is more of an observation, I think. It says that Kenya has had some, it's nice to see lots of Kenyans today on this webinar. Kenya has had some success for CDR at the tribunal. could be the pointers, markers for countries like Nigeria that are just adopting arbitration in sports sector. Neighbors, Uganda, now have a sports law that provides for arbitration. Congratulations, Uganda. That's awesome. I don't know when Nigeria is going to join the bandwagon. Honestly, we're waiting. So I don't know, Leandro, would you like to take that? What pointers, markers? You talked about collaboration though. So what do you think those of us still waiting in the waiting room can do until we get a Sports Act officially adopted?
Well, I can make a parallel with other areas, as I'm not technically an expert in the sports sector itself, but in IP, for example, it's very interesting always to see what others are doing. We are very lucky here at WIPO because we are exposed to, we start the day working in Korea and we finish the day working in Mexico, right? So we go the whole day working with people from around the world as the day goes by. So we have access to a lot of knowledge and to see, for example, in the area of ADR, what are the practices, what works in one place, what's the approach to dispute resolution. There's also a cultural aspect. In some places, you see more of a litigation culture. In others, more of mediation or compromise culture. So I think it's good to see what's happening in other places at the regional level, in countries that have a similar background in different aspects, and learn from both the success and the horror stories too. It's like sometimes, we run programs in different places and they might work better in a place than in other ones. So we learn and we adapt and have this agile mentality of adapting and testing. We also do a lot of pilot projects. When we start small and then we test it and we see and we get feedback from the industry, from the users. Whatever you build, it has to be useful for whoever is going to use it. So for that, you need to learn, you need to understand, you need to see what are the needs, and based on that, build all the infrastructure around. Otherwise, you may end up with building something that is not used. And of course, that's a waste of time and other resources for everybody.
Thank you for the contribution. Well, unfortunately, it's such a stimulating session, but I do have to draw it to a close. So I would like both panelists to end with parting thoughts. It could be anything, whether it's technical suggestion on arbitration or disputes, or it could be something along the lines of personal development, career development. So I'll start with Madam Onyango. What would be your parting comments from today's session to the audience? What do you want the audience to take away?
It's interesting that you started by making me look like I have been around and know too much, and I've just realized I don't. Leandro has spoken and I felt naked. I don't know that area of sports too well. Let's not sit in comfort zones. That is, in fact, our biggest problem, because many people will not want to take up a sports matter because, oh, I don't know. A doping matter, I don't know. I got into doping accidentally from an insult from the then region, what is called the RADO officer. She needed to put up a panel. She called me and I said, oh, I don't know. And she told me, are you a lawyer or a fake? I felt insulted and I picked up the challenge. Now I'm the chair of Africa, the Continental Result Management Panel. Take up challenges, I think. Be ready to go wrong in a few of those issues, but then you learn from each one of those incidents. We are lawyers. Most people basic is the legal background. If you learned all these many laws, you can learn the sports one. So take up the challenge. I look forward to having many of you presenting clients under the Africa Continental Result Management Panel. Thank you.
Leandro, over to you before our branch chair gives the passing remark.
Well, very, very quickly, I think I agree with Jane, of course. That's great advice. And these days, we don't have any excuses, right? So the information is out there where you can go. There are lots of free courses that you can take. lots of materials. Sometimes it's a bit overwhelming I think for young professionals, because there's too much information and you need to pick and choose. But go to the established institutions and learn and see the courses they offer, participate in events like today. We have a chance to hear from people that have been working in the industry, in the sector, and then you can decide whether you think it's a good opportunity to go into the area or not. So that's my advice. Be proactive, basically. It's like don't just like be in the comfort zone and trying to go out and learn. That's the only way to find out if you're interested in the area or not.
Excellent. Thank you so much. And before we wrap up, finally, I would like to allow my honorable branch chair, the amiable and amazing Mrs. Olushola Adegbomire, to please take the floor and her final closing remarks for this fantastic session. Thank you, ma'am. You're welcome.
Thank you, ma'am. You're welcome. Thank you, Beverly. It has really been an amazing session. I mean, this has been our first in the specialist arbitration webinar series, and this has been very encouraging. We've had about 130 people from all over Africa, and people who have joined have actually stayed the 1 hour. So that tells you that you've done a great job. So I want to first say a big thank you to our panelists, to Leandro, to Njeri, all the way from East Africa. If you are flying, it would be a long flight, and same thing with Leandro. And thank you to our own Beverly, our own sports experts in Nigeria. Thank you so much to all three of you. This has been a wonderful event. I want to thank everybody, the people who have put it together, the education and the mentorship committees, Dr. Agbelusi, Sheila Ojo-SAN, they've all done a great job. And then, you know, this has been very impactful. I want to thank all those who have attended. Thank you for attending, because if we put this together and nobody comes, then there's no point. But so I want to thank you all for attending. I'm sure this has been impactful for everybody, including me. I mean, now so many opportunities have been thrown up of places where we can go and expand our horizon and expand our work in ADR. You know, and the whole idea of this arbitration specialist series is to help us know what else we can be doing in the area of ADR and arbitration. What other things can we be doing? It's not just general arbitration. There's so many opportunities. And so this one has really opened. I know when the websites were thrown up, you know, it's like when the WIPO one came up for young people, I'm sure a lot of the young people have screenshots it and all the other things. This has just been amazing. You know, we've had people from all over Africa. I want to thank the Africa chairs as well. When I sent this flyer to them, they also put it up in their own different countries, platforms, and so on. And I believe that everybody has been truly impacted by this program, really impacted, new opportunities, just like Leandro and Njeri, everybody, you're all talking about how you checked one place, check the other, and you got this opportunity. I'm sure many people will be checking many places, and I thank you for not holding back. Toscano, Leandro, and Njeri, Beverly, thank you for not holding back on the information you have. You've shared of your own information, shared of yourself. Thank you very much. And next series, because they're telling me flashing time up, our next series is going to be maritime arbitration. So that's another one you should check out. Another specialist arbitration series will be on maritime arbitration. We'll have specialists in that area as well. At the end of June, we're looking at June 20, but the flyers will soon be out on maritime arbitration, and we look forward to seeing you all. All these things will help you to decide, what can I really do in arbitration? Which areas can I focus on? So thank you again. Once again, Leandro and Njeri, Beverly, a big, big thank you to all three of you. You've done an amazing job. And I see a lot of our other specialists on this webinar, people that we will also be calling them to speak in their own areas. I'm sure some of them already know who I'm talking about, but I'm not going to mention names. They are specialists as well in other areas, investment treaty, maritime, and we'll be calling on them to speak in their own area. So once again, thank you very much. Before I get bumped off, thank you. Beverley, do you want me to go on? Okay, they say no. So, well, on behalf of the branch, I want to close this meeting and to say that we looked, this whole meeting will be actually on our YouTube page, so that you can go back to YouTube and you can listen to everything again in case you have missed anything. It will be on our YouTube page, and you can go back and listen to it all over again.
Thank you, Ma.
Thank
Sorry,
you.
I got logged out. Thank you, Ma. Thank
No.
you so much. Thank you to all our panelists.
Thank you.
Thank you,
big
Bank
thank
Chair,
you.
for all the support you give to sport arbitration. We appreciate you. More grace to you.
Thank you.
Have a
Thank you.
lovely
Thank you.
weekend.
Thank you.
Yeah.
Bye-bye.
Bye-bye. Bye-bye. Bye.